One, and you are live.
Good morning, everybody. It's time for me to open the public inquiry. My name is Matthew Nunn, and I'm the inspector that's been appointed by the Secretary of State to conduct this inquiry and to determine this appeal. The appeal is made by Catesby Strategic Land Limited, and it concerns the refusal of planning permission by Malden District Council for a development comprising an outline application with all matters reserved except for the means of access from Steeple Road and Burnham Road for a residential development of up to 160 dwellings, including affordable housing, 10% bungalows, 100 square metres of office hub floor space, 0.221 hectares of land for children's day nursery and associated parking, use class E, a community park, sustainable drainage system and associated infrastructure on land north of the Groves in Burnham, in Latchingdon, in Essex. That is the revised description of development. We discussed some minor changes at the case management conference to the description, which involved increasing the percentage of bungalows from 5 to 10%, amongst other things. But given they were very minor in scope, we agreed that we could proceed on that basis. And I understand the council has proceeded to consult on that basis as well. Is that correct?
Yes, I would confirm that's correct.
Thank you. So just before we get into the main part of the inquiry, just a few preliminary matters, formalities just to go through before I explain how we will proceed today and on subsequent days. First of all, can I ask people, please, if they could turn their telephones off or put them on silent mode so we don't get any disturbances during today's proceedings. I wonder if a representative of the council could advise on emergency exits should we need to exit the building.
Yes, sir. We have the exit there. There's also exit that way. I'd also confirm that there's no planned fire alarms today.
Thank you. Thank you very much. So if the alarm sounds, then we all need to leave the building. The event is being live streamed, I understand, so that people who aren't here today can observe proceedings in the comfort of their own homes if they so wish. So I hope everyone is happy with that. If they're not, please let me know. So I'll come now on to who we have appearing at the inquiry today. First of all, perhaps I will turn to the appellant and I'll ask the appellant to introduce themselves and also for me to be advised of the witnesses to be called.
Good morning, sir. My name is Cannock, excuse me, C-A-N-N-O-C-K, initial G for Giles. I am King's Counsel from King's Chambers. I'm instructed by Jeff Armstrong through the scheme of direct professional access, and I have 3 witnesses: Jamie Roberts, dealing with affordable housing, Charles Milcreast, dealing with the impact on the identity of Latchingdon, and Jeff Armstrong, dealing with planning policy and the planning balance.
Thank you, Mr. Cannock. That is clear. And for the council?
So good morning. My name's Luke Wilcox. I'm a barrister from Landmark Chambers. The only witness I'll be calling, sir, is Mr. David Coleman. So appended to my opening statement, which I'll circulate in due course, there's a list of the relevant qualifications, who's instructing whom and so on, so that you'll have that in writing.
Thank you, Mr. Wilcox. That's clear. In terms of those wishing to speak, I've been provided with a list of people who wish to speak. What I'm proposing to do is to hear those persons after we hear the opening submissions of the main party. So I will shortly ask the main parties, first the appellant and then the council, to make their opening submissions, which sets out the main arguments of each side's case. In terms of the proofs I've been supplied with, I've had proofs from the appellant, from Mr. Armstrong, Mr. Roberts and Mr. Milcreast, and from the council I've had a proof from Mr. Coleman. I think that's all I'm expecting. I've had no further proofs. Just to say that I've read the proofs and I would expect them to be taken largely as read. I've also received statements of common ground on planning matters and on housing land supply as well. Just a general point that I would make at this stage, all the documents and evidence should have already been provided, should be before me. I don't wish to receive any further late evidence unless it's absolutely necessary. If I am asked to accept any late evidence, I'll need to be satisfied that it's relevant, and I'll need to seek parties' views on whether it should be accepted or not. And of course, the problem with late evidence is it may require an adjournment of the inquiry to allow myself and also others the opportunity to read it, and that can of course have a risk of costs. In terms of the site visit, it's normal procedure to make a formal inspection of the site in due course. I'll arrange that in due course. I just need to make it clear to everybody that the site visit is solely for me to observe the physical characteristics of the site in the light of the evidence that I've heard. There will be no discussion about the merits of the case on site. So any points that people want to make should be made here in this room, in this forum, rather than on the site visit. So I hope that's clear to everybody. Now, in terms of how I intend to proceed today and over the coming days, as probably everyone is aware, this is a formal public inquiry. So its purpose is to test the evidence in order to enable me to fully understand the issues, so that I can reach a decision on whether to allow or to dismiss the appeal, and for everybody to put across their points in an ordered fashion. So I'm proposing to run the inquiry in the following order. When I've concluded my opening remarks, I will invite the main parties, as I say, to make brief opening submissions. Mr. Cannock will go first, and then Mr. Wilcox, and this will hopefully enable everybody to understand the main arguments of each side. As I said, I'll then hear any interested parties. I've been provided helpfully with a list of people who I assume are objecting to the proposal, and it's obviously very important that interested parties can participate if they wish to do so. I'm very aware that this is a very controversial scheme. I observed a number of people in front of the council offices who were obviously concerned about the development, so I saw that as I came in. So I am very aware of the concerns that have been raised. I've read people's objections, of which there are many. Just to say to everyone, I don't need to hear the same evidence many times over. So, you know, a point repeated isn't necessarily a point better made. So just to assure everybody, I have read everybody's objections, and there's no need to repeat material. But by all means, you know, draw my attention to anything specific that you want me to be aware of. Once we've heard the opening parties' submissions and we've heard the objectors, we will then hear the evidence of the main parties, i.e. the council and the appellant. I propose to follow the traditional order of the council having its evidence heard first, and then the appellant. And as I discussed at the case management conference that we had a few months ago, I'm expecting the evidence to be heard in the conventional manner, i.e. by formal presentation and cross-examination. Is that what, Mr. Wilcox, you're nodding?
I am nodding, so yes. My learned friend and I had a discussion last night, and we'd reached the same conclusion, sir. Yes.
Yes. You're happy with that, Mr. Cannock?
Absolutely, sir. Thank you.
Yeah. So, as I say, formal presentation. So that means that each side presents a witness, and then the other side has the opportunity to cross-examine that witness. That's how it works in essence. And then we move through each witness in the order that each side wishes to call their witnesses. Obviously, Mr. Wilcox, you've only got one witness, so you have a limited choice in terms of the order in which you you take your witness. But Mr. Cannock, did you have any particular order you were planning to call your witnesses?
Yes, sir. 2 points, if I may. The first concerns the evidence of Mr. Roberts. And my learned friend and I, I'm grateful to him. As you would expect, and to those listening, this is a perfectly usual thing that advocates do to just try and manage inquiry time as best as possible. He doesn't have any questions for Mr. Roberts. Mr. Roberts, you'll recall, is dealing with affordable housing, need, supply, affordability, issues like that. That being the case, he's content that evidence is taken as read. But that being his position, sir, I don't particularly feel the need to call him formally, as it were, just to go through an examination in chief, a document that you've indicated you've read, and that I can draw out some salient points with Mr. Coleman and in closing submission. So I don't need an answer now, but if you could consider sort of during the course of the day whether you would have any particular questions for Mr. Roberts. But if you don't, sir, then it may be that I don't need to call him at all. That's the first point. The second point is the order would, if he's required, be Mr. Roberts, Mr. Milcreast, Mr. Armstrong.
Right. So Mr. Roberts, Mr. Milcreast, and Mr. Armstrong. Okay. Well, I have. Thank you for that, Mr. Cannock. If the council has no questions to put on matters of affordable housing to Mr. Roberts, is that correct, Mr. Wilcox?
So yes, that is correct. Mr. Roberts' evidence, for your purposes, as it were, feeds into the weight to be given to affordable housing, and on that matter, the planners are agreed.
Yes.
So on that basis, sir, it seems a disproportionate use of inquiry time.
I'm all in favour of saving inquiry time, so I'm more than happy to take that evidence as read, and I don't see that it would be necessary in those circumstances to call Mr. Roberts for formal evidence if the parties are happy. Yes, I mean, it seems to me that the issues of concern to residents is more. Obviously, there are many concerns, but I'm not sure that the finer details of affordable housing provision across the borough is necessarily foremost in people's minds. I think it's more, obviously, the effect on the character and appearance of the area, the effect on local services that people are concerned about, and traffic and so on, so forth. Those kind of issues. So I'm happy to proceed on that basis if that's agreed with the parties.
Well, sir, I'm really grateful for that. Of course, we'll hear from interested parties and maybe members this morning. If something gets thrown up, then perhaps we'll revisit that. But certainly then, as things currently stand, my intention would be not to call Mr. Roberts and to inform him accordingly. Thank you.
Thank you for that, Mr. Cannock. Right. Once I've heard the substantive evidence of the parties and indeed of people attending who want to speak. We'll then have a roundtable discussion. I say roundtable, it means it's not a formal cross-examination process. It's merely a discussion about conditions that could be applied to any planning permission in the event I was minded to allow the appeal. Just to assure everybody, this is part of the normal process with these kind of events. We always discuss conditions in just to be clear as to what could be put on any permission if it were granted. It certainly doesn't indicate that I've made my mind up on this appeal or that I've prejudged the case. It's merely a process that we go through. And similarly, we will also have a discussion about the planning obligation, which I believe has been provided in draft form. I recall seeing a copy of that. I don't think it's been finalised yet. Obviously, that sets out obligations that the developer would undertake to provide were the appeal allowed. So again, that's a normal part of the process. It doesn't mean that I've prejudged this appeal. I have to be, with both the conditions and the obligation, I have to consider both against the relevant regulations and government policy. I hesitate to raise the issue of costs, and I'm not necessarily wanting to get into that now, but if any party does want to make an application for costs, they should do so before I close the inquiry. I'll leave it there for the time being. Just to say also, I do have the power to award costs myself if I feel the need. And then right at the end of the process, I will hear closing submissions for all the main parties. So I will hear from Mr. Wilcox first and then Mr. Cannock, which is essentially a summary of each other's case. Okay, so that's how things will proceed over the next few days. We have 4 days programmed. Whether we will need the full 4 days, I don't know, in the light of the number of witnesses. I don't know if anyone has any thoughts on that, Mr. Wilcox?
So I strongly suspect, and I rather hope, that we can be done in 3, given that there are only going to be 3 witnesses now requiring to be examined and only 3 interested parties wishing to speak.
Yes.
My hopes would be that we could get through Mr. Coleman today,
Yes.
so that he can be released by the end of the day. I'd certainly like to avoid him remaining in evidence overnight.
Yes.
That would obviously be some inconvenience to my team. If so, we can get through Mr. Coleman today. We should, I think, be able to get through Mr. Milcreast and Mr. Armstrong tomorrow.
Yes.
I don't have a vast amount for Mr. Milcreast either. Much of his evidence goes to landscape and visual issues, which I should be aware. So I understand why the appellants put the evidence in, but it's not a dispute as between the main parties.
No.
So that being so, I would hope would be able to deal with the conditions and obligations roundtable on Thursday morning and close on Thursday afternoon.
It would be very good if we could. And I don't know, Mr. Cannock, if you have any observations on that.
Well, I'm always cautiously optimistic, sir, and that's perhaps as far as I will go. But we'll know more at the end of the day. We will.
Just to make it clear to everybody, on sitting days, I would start at 10 o'clock usually, and we would normally have a break for lunch of around an hour, and then we would have mid-morning breaks and mid-afternoon breaks at a time that would be convenient in terms of evidence. So they won't necessarily be fixed times. I think it's easier and better to see how we get on, and then we can take an appropriate break mid-morning and mid-afternoon. In terms of, I wouldn't sit beyond 5 o'clock unless there's extenuating circumstances. And individual inquiry sessions, I don't normally like to go beyond 1.5 hours, as I think longer periods are generally less productive. So, just going back to the issue of time, I think Mr. Cannock, you did indicate very helpfully that you would be about 3 hours with Mr. Coleman in cross-examination.
Yes, sir.
Yeah. So, with any luck, we should be able to get through Mr. Coleman today with any.
Yes, sir. And look, I'm committed to doing that. My sort of concern is it is a 3-hour cross-examination.
Yeah.
And what I wouldn't want to do is to try and put a quart in a pint pot and everyone sort of be clock watching around about 5 o'clock.
No.
When we've otherwise got time in the inquiry.
Yes,
Now,
yes.
I understand the point about not wanting to split overnight. So I just think, progress today will be determined by what progress we make this morning.
I understand that. And that's why, given the very limited number of witnesses, really, we don't have a huge number of witnesses. I haven't set out a sort of detailed program as I would on certain, cases where we might have very many witnesses for each side. I thought, given the relatively, if in fact it's going to be 2 for you, Mr. Cannock, and 1 for you, Mr. Wilcox, it really doesn't seem necessary. So we'll keep an eye on things, and we'll see how we get on. I'll keep matters in terms of timings under close review, and as time goes on, we'll probably be better placed to understand the sort of broad structure of the timetable as we proceed. Are there any other procedural points anyone wants to raise at this point?
So might I raise, I've sort of got 4 briefly,
Yes.
just touching on a couple of matters that you've raised. Firstly, you raised the issue of consultation.
Yes.
So minor amendment to the description of development. Without prejudice to our contention, consultation wasn't required. A consultation exercise was undertaken. My instructions and understanding is that there was one response to that consultation from the parish council, and it was identical to a previous.
Yes.
So providing you have that, sir.
Yes.
The second point is the section 106. We're very grateful to the assistance of the local planning authority. We have a document which is agreed as between the 2 of us. Of course, as you've said, sir, entirely without prejudice to their contention that consent should be refused. But we have an agreed section 106 obligation. We have half a chance, sir, of getting that signed and dated by the end of the inquiry. But subject to you having had an early sight on it, because obviously we can't do that if you're going to require some amendments. And equally, sir, there is the opportunity for my instructing solicitor who's drafted the document to be here for the roundtable session again, if you think that is helpful. So can I just ask you to consider those 2 matters? But otherwise, I'm hopeful that could be a relatively straightforward roundtable session with a document that's agreed that all parties understand. That's what I'm sort of angling for, if that helps.
Yes.
That leaves then a SIL compliance statement. Now, there are no contributions within the section 106 which are actively contested, if I can put it that way. But that does then mean that there's an issue as between you and the local planning authority as to whether they comply with the statutory and the planning policy tests. We have, we have, perhaps I could just characterise it as a concern about the bus contribution. And so we've not seen that SIL compliance statement, but I wouldn't want anyone to think that that's just going to be a rubber stamp. We would like to have sight of it, and it may be that there are some observations in the round table. So no undue pressure on the local authority, but self-evidently, the sooner we can see that, the better. And that leaves my 4th point, sir, which is conditions. We had a set of draft conditions, I think, attached to the officer recommendation because that was for approval. If the local authority are wanting something different on reflection, then as soon as we can get those, we can work through those again on a without prejudice basis to make that session go as smoothly as possible. So it would be helpful to know if we're sort of expecting an updated list of conditions or what the position is there. Thank you, sir.
Thank you, Mr. Cannock. I'll come to Mr. Wilcox in a minute. Thank you for confirming the issue of the consultation. I think a letter did go out. I saw a letter that made it very clear that everyone's objections that had been previously made were being taken into account in any event. You know, it was a minor adjustment to the description, and the letter just brought people's attention to that. And if they wanted to make additional comments, then of course the letter said, of course you can, but just to assure everyone that their previous objections would be taken into account of. So that was my understanding of what happened in the letter that went out advising people of the inquiry. I don't know if anyone from the council wants to, whether you, Mr. Wilcox, or Mr. Johnson, I see in my corner of my eye there. I don't know whether you want to speak on that.
No.
Perhaps, Mr. Johnson, perhaps you should introduce yourself, because you haven't actually formally introduced yourself, just for the purposes of people who might be observing proceedings.
Okay, thank you, sir. My name is Michael Johnson. I'm the Head of Development Management and Building Control in Malden Council. I'm here supporting our consultant team on this appeal. I think I'm probably known to a fair few in here, so thank you for that.
Thank you.
Yes, on the point of the consultation,
Yes.
it's as you stated.
Yes.
There are no further comments on that regard. Thank you.
Okay, thank you, Mr. Johnson. In terms of the Section 106, thank you, Mr. Cannock, for what you said. I'm happy to delay formally signing that until we've had the session, obviously, because there may be things arising from the roundtable discussion that, you know, there may be tweaks that may be needed or changes or so and so on. So I think it would be more sensible to delay any. I'm not going to insist that it's completed before the end of the inquiry. I mean, I'm happy to give a week or so to allow after the inquiry closes.
Understood, sir. Thank you.
So just to take any pressure off with that. In terms of the SIL compliance statement, yes, Mr. Cannock, I agree. The council will need to produce a statement justifying why they've asked for certain items. I note your issue about the bus contribution. And conditions, indeed, we do need a draft schedule of conditions that we can discuss at the round table. I'm not sure what status we are with that at the moment, but we will need a draft to be provided before that session. Mr. Wilcox, did you want to say anything?
Yes, so just to assist on those 2 points. On the SIL compliance statement, that's, I'm hoping, going to be ready by the end of the day. It's work in progress, sir. Similarly with the conditions, we're going through at the moment, so under the surface, as it were, we're going through the latest round of comments on those, and they'll be returned to the appellant as soon as we can. Again, I'm hoping that will be today, and I'm very much hopeful that we'll have an agreed set for you, sir, in good time for Thursday morning.
Thank you, Mr. Wilcox, for that. So, if there are no other procedural points anyone wants to raise at this stage, I just outline what I consider to be the main issues in this inquiry in terms of between the main parties, let's put it that way. I'm very aware that interested parties have raised a wide variety of matters, which I'm sure when people speak they will make their views known to the inquiry. But in the light of the discussions that we had at the case management conference and further correspondence from the council, the main issues as I see them, these are between the main parties, are the acceptability of the development outside the boundary. That's the first point. The second is the effect of the proposal on the character and appearance of the area, including the landscape. And finally, the planning balance, as we call it in planning terms, where we have to essentially assess the pros and cons of the proposal. I'm aware that a lot of residents have raised a number of different issues, which, of course, I will also have to deal with in my decision. as well. And I will, as I say, I've read everyone's letters, and I'm sure people will be speaking this morning and highlight particular areas of concern. So those are, as I see it, the main issues that we need to address between the council and the appellant. I don't know if anyone has any comments on that.
So I've recast those slightly
Yes.
in opening, but I can address you then. I don't need to take time.
Well,
now.
as I say, these are only indicative. They're not set in stone by any means. I'm more than happy to hear how you've recast them, Mr. Cannock.
The simple point is, and I'm grateful to my learned friend's indication earlier, that there's no landscape and visual impact case. The issue, as I understand it, is whether there's an impact on the identity of Latchingdon. Okay. So I think that issue 2 can be recast just slightly more precisely, and therefore save time with the evidence of Mr. Milcreast.
I'm, as I say, I'm happy to hear the evidence, and obviously, when I've heard all the evidence, I'll probably be better placed to firm up the main issues, as it were. I think that that was how I cast them in my case management note, I think.
That's right, sir, yes. Yeah. Like my learned friend, I've also slightly recast them in the light of the narrowing of the issues since the case management conference, so you'll see that in opening.
Thank you. But as I just to reiterate, I am aware that local residents have a wide range of concerns that may not have been captured in what I've just said, and that doesn't mean they won't be considered, because they will be, and they will be given full. I'll go through all the points that are raised and address them accordingly. All right. In which case, I think we can. I will ask Mr. Cannock to make his opening statement. Thank you, Mr. Cannock.
So I put this down in writing, so I'll go through it as briefly as I can, and it may be that I don't read every word, but I thought, bearing in mind I understood that there would be some local resident interest, I thought it was helpful to perhaps set out some matters in a little detail.
I think it is, certainly, Mr. Cannock, so that everyone is aware of the appellant's arguments. I'll number this document ID 1 as inquiry document number 1 for administrative purposes. Thank you.
Thank you, sir. The context for this appeal is the national imperative to boost significantly the supply of housing. There's a recognition from central government that the planning system has simply failed to deliver sufficient homes for a protracted period of time, and this can no longer be tolerated. The housing crisis, exacerbated by inflation, rising build costs, repeated rises in interest rates and the cost of living, a daily news story, has been expressed most recently in the white papers Fixing Our Broken Housing Market and Planning for the Future. This is a national imperative which has a clear local expression. Since the adoption of the local plan in 2017, the authority has repeatedly failed to meet the plan's minimum annual housing requirement and/or its planned trajectory, against which there is a significant shortfall. The authority has repeatedly failed to demonstrate a 5-year supply. Whilst the authority can currently demonstrate an agreed 5.9-year supply, it can only do so because of its significant reliance on greenfield housing sites outside settlement boundaries and because of a reduced local housing need applying the standard method. Additional greenfield housing is therefore required to maintain the 5-year supply and meet the minimum housing requirement across the planned period. Further, the need for affordable housing is acute. The latest assessment is a net need for 209 affordable homes, 2020 to 2040, which the council are failing to meet by a significant margin. Consequently, lower quartile affordability has risen exponentially, such that even modest housing is 11.67 times income and unaffordable to vast swathes of the local population. This is the antithesis of national policy, which seeks to boost the supply of housing to meet up-to-date objective needs of all. In that context, as officers have expressly recognised in the technical review of the plan, the allocations have failed to deliver as planned, and the plan policies are too restrictive to allow sustainable development. As a result, the council have been and remain significantly dependent on greenfield sites outside the settlement boundaries of sustainable settlements to meet their urgent need for more market and affordable housing. This is a proposal which delivers the significant benefits of more market homes, 50% affordable homes, 10% bungalows to assist in meeting the needs of older people, with substantial economic benefits on an accessible site immediately adjacent to the settlement of Latchingdon. On that basis, the application was unequivocally recommended for approval. The proposal concerns an outline application for up to 160 new homes, of which 50% will be affordable and 10% bungalows. All matters are reserved save to access. Access means the point of access and not the internal road layout. 5.87 hectares of the site would be development area, including gardens and parking areas. 4.25 hectares of the site would comprise public open space and green infrastructure, including a community park, ecological enhancement area, foot and cycle paths, strategic landscaping, and SUDs. And the appeal proposal comprises the essential following elements, and so I'll skip through this if I may. Up to 160 new homes, 100 square metre office hub, provision of land for a children's day nursery, retention of the existing World War II pillbox, a mix of dwellings, 2 to 5 beds, 50% affordable housing, 10% bungalows, the provision of a new community park, a sustainable urban drainage system, the retention of important trees, woodland and hedgerows in the site and on the boundaries with enhanced landscape planting to reinforce the landscape edges to the site, new soft landscaping features within the development, new vehicular, pedestrian and cycle accesses from Steeple Road to the north and Burnham Road to the south, a policy-compliant level of car and cycle parking, the reduction of carbon emissions in line with the submitted sustainability statement, and electric car charging points. The proposal does not comprise EIA development. The plans for determination are agreed, and the illustrative master plan shows one way in which the above proposal could be accommodated. It's agreed that the reserved matters could deliver a high-quality design on the site, and the authority no longer relies on conflict with policies D1 and H4. Turning then to the determination by the Council. At the time of the determination, there were no outstanding requests for further information from the authority and no technical objections from statutory consultees, which could not be overcome by condition and planning obligation. The application was recommended for approval. It was, however, refused by members for a single reason. And so I've set that out and you'll be familiar with it. Article 35 of the Development Management Procedure Order requires that reasons for refusal must state clearly and precisely their full reasons for refusal, and the reason for refusal, as is noted in the CMC note, raises a single objection: the location of the site outside the settlement boundary. The reason for refusal makes no reference to, amongst other things, the accessibility of the site, the sustainability of Latchingdon, or the impact on the identity of Latchingdon. Such matters fall outside the resolved position of the authority. Whilst reference was made to the impact on infrastructure in the authority's statement of case, this was addressed at the CMC, and the authority have subsequently and helpfully clarified that we are no longer pursuing the infrastructure point in the absence of objections from statutory consultees, and that is reflected in the Statement of Common Ground. And in that context, sir, then the main issues reflect the single issue of the reasons for refusal. Firstly, whether the proposal complies with the development plan. Secondly, the acceptability of development outside the settlement boundary. Thirdly, the effect of the proposal on the identity of Latchingdon. Fourthly, the benefits of the proposal. Fifthly, whether material considerations outweighed the agreed conflict with the development plan. And those main issues fall to be determined in accordance with the development plan unless material considerations indicate otherwise, and so far as relevant, the development plan comprises the Malden Local Development Plan 2014 to 2029. But sir, given that the appellant accepts that there's a conflict with policies S1, S2 and S8, the determining issue is whether there are material considerations which outweigh such conflict. There's a powerful consensus of professional evidence between the appellant and the professional officers of the council that consent should be granted on that basis, and it's submitted that significant weight should attach to such a consensus of professional evidence. And then, sir, I turn to the development plan and the housing requirement. The plan was adopted in July 2017. It runs for 15 years between 2014 and 2029. And whilst the plan is more than 5 years old, it's not been the subject of a statutory update, and accordingly its policies remain extant. The housing requirement in policy S2 is a minimum of 4650 new homes, 310 dwellings per annum. The housing requirement had been uplifted from the submission draft of 294 dwellings per annum for two reasons. Firstly, to address outmigration from London, and secondly, the more fundamental issue, to address the requirement to support a minimum of 2,000 net additional jobs by 2029 in policy E1. And the EIP inspector considered that 310 dwellings per annum was necessary and justified to support this extant minimum level of economic growth and job creation. To meet the requirement of 4,650 new homes, the plan identified a supply of 5,108, comprising completions, extant planning permissions, allocations at Malden, Heybridge and Burnham on Crouch, with an allowance from neighbourhood plans and windfalls. The spatial distribution of housing was essentially to contain the majority of new housing within and adjacent to the main settlements on the allocated sites, and to allow a small amount of growth in the villages through neighbourhood plans and the windfall allowance. And on that basis, the settlement boundaries were drawn tightly around the 2014 settlements and allocated sites. And the spatial strategy to 2029 was therefore simple: to promote housing inside the settlement boundaries on allocations at the three main settlements, and to restrain housing at lower tier settlements, save through neighbourhood plans, and thereby restrict housing as a spatial approach on sites outside settlement boundaries because it was not needed. On that basis, it's agreed that the proposal conflicts with the spatial strategy and spatial distribution of housing in the development plan. The site lies outside the settlement boundary of Latchingdon, which is classified as a smaller village. The proposal is therefore contrary to policies S1, S2 and S8, which simply preclude market housing outside settlement boundaries. The appellant does not accept, however, that there is any tangible land use planning harm which flows from the location outside the settlement boundary. In particular, there's no prejudice to the delivery of the local development plan spatial strategy in policy S2, and the authority don't argue the contrary. And secondly, the proposal will not compromise the identity of Latchingdon within the terms of policy S112. Further, it's important to note that in including that there is conflict with the development plan, there's no policy requirement or even scope to assess, amongst other things, the need for market housing, the need for affordable housing, the need for specialist accommodation for older people, socio-economic benefits of the proposal, accessibility, sustainability of the settlement, the acceptability of the impact on the character appearance of the area, and or the planning balance. And it follows, therefore, sir, that such matters must therefore be considered separately. So I turn then briefly to the performance of that spatial strategy. Whilst the authority claimed a 5-year supply at the examination in public, it quickly became clear that the authority could not demonstrate this minimum policy requirement. And so I set out then the 5-year supply in April 2020, 21 and 22. In April 22 it was 3.66 years. Further, the agreed evidence demonstrates that there's been a significant shortfall of 536 homes in the first 5 years of the plan. There's been a significant shortfall of 109 homes against the annualised requirement, and a very significant shortfall of 914 homes against the planning housing trajectory, equivalent to 3 years' supply. The explanation is the failure of the allocations to deliver as planned. There is a current 910 unit shortfall in the planned trajectory of the allocated sites. Indeed, the only reason why the shortfalls have not been even more pronounced is because of the significant number of permissions on greenfield windfall sites. 633 homes have been consented in the last 5 years, 32% of completions, and this is significantly above the planned windfall rate and includes sites which lie outside the settlement boundaries and contrary to the development plan. There has therefore been a significant failure in the spatial strategy of the plan. Indeed, this has been expressly recognised in the authority's technical review of the plan, which recognised, amongst other things, that the plan is inflexible or not adequately flexible. There's no policy setting out how the windfall allowance was to be delivered. The policies are not written very clearly. The policy wording means it's difficult to obtain permission. Settlement boundaries squeeze out opportunities for windfalls immediately outside the settlement boundary. Housing outside settlement boundaries are generally refused, even when it's adjacent to existing settlements and acceptable in all other regards, and the settlement hierarchy is out of date and not robust, resulting in applications being refused in settlements which could otherwise be deemed to be acceptable. And so you will note that those last two technical points taken by officers have a particular resonance in this application. In that context, it's agreed that the authority has carried out a review and determined that an update is required. The agreed conflict with policy needs to be considered in that context. And so I then turn to consider the material considerations, and we contend that there's a powerful set of material considerations which outweigh the conflict with the development plan, and these can be considered against the three roles of sustainable development in the NPPF. So I turn then to the social role and the need for market housing. It's agreed there's a 5-year supply of 5.97 years. However, this is not a ceiling or cap on development. Rather, it's a simple policy mechanism which engages the tilted balance. The requirement for the authority to demonstrate a 5-year supply is the minimum requirement of national policy set against a minimum housing requirement. Further, the local housing need requirement of 279 is lower than the extant plan requirement required to meet the minimum economic growth job creation target. The agreed supply is 1665. However, 620 homes, 37% of them are on windfall sites. Without them, the supply is a mere 4.45 years. Of the 620 homes, 523, or 31% of the total supply, are on greenfield sites outside the settlement boundaries. It follows that the authority can only demonstrate a 5-year supply because of a very significant proportion of homes being consented on greenfield sites outside settlement boundaries. Further, housing land supply is set to fall even based on the authority's flawed trajectory. Accordingly, further windfall sites will be required if the authority is to maintain a minimum 5-year supply. And finally, there remains a current plan shortfall of 304 homes to meet the minimum requirement by 2029, and therefore consents need to be granted now to meet the minimum need by 2029. And in the context of the plan requirement being a minimum and the 5-year supply being a minimum requirement, it's unanswerable that the benefits of delivering more market homes is a material consideration of significant weight. Turning to affordable housing, 80% or 50% or 80 homes will be affordable. The agreed 10-year split is 75% affordable homes and 25% intermediate ownership. The plan recognises a significant shortfall in the availability of affordable homes. Increasing the supply is one of the key priorities. On the basis of the SHMA 2014, the EIP inspector concluded that a need of 130 affordable homes could be met through the allocations with limited rural exception schemes. Such a conclusion has proven to be demonstrably flawed. The SHMA 2014 actually identified a net need figure of 201 affordable homes per annum from 2014 to 2019, 154 2014 to 2029, and the figure of 130 took no account of meeting the significant backlog. Accordingly, the need in 2014 was 154 affordable homes per annum. The Council's latest objective analysis demonstrates a total net need of 209 affordable homes per annum, or 4,180 between 2020 and 2040. The local housing need assessment acknowledges a notable need and encourages housing delivery to be maximised where opportunities arise to address this important and pressing issue. The reality is that such a need will have to be delivered by market homes on viable greenfield sites outside settlement boundaries. In the planned period to date, the authority has managed just 581 affordable homes net, or 65 affordable homes per annum. This is less than half of the identified need. Performance is worse against the 2021 requirement. The shortfall is 305 affordable homes in just 3 years. It's clear that the delivery of affordable homes has been abject. The authority has identified that it could deliver 499 affordable homes in the 5-year period. On that basis, the shortfall would exceed 1,000 affordable homes. the plan will unanswerably fail to deliver the required level of affordable homes to meet the objective need. Further or alternatively, there are 981 households on the housing register, and each one represents a household in need now. Finally, as a result of the failure to deliver enough market and affordable housing, house prices have risen 18% since 2014. The ratio of lower quartile house prices to lower quartile earnings is now at 11.67. Rents have also increased. The average age of a first-time buyer is now approximately 40 years old. It follows that housing has become unaffordable for a vast swathe of the local population. It follows that the weight to be attached to the benefits of delivering 80 affordable homes to meet the identified need without public subsidy is substantial. 10% of the homes will be bungalows, and the planning practice guidance, national guidance, states that the need for specialist accommodation for older people is critical. The demographic time bomb has a local expression. The authority's specialist needs supplementary planning document states that 67.3% of the population growth will be in the over 65s. The authority therefore recognises that it's a priority to meet their needs, which are considered to be acute. Bungalows are recognised in national and local policy as being a form of specialist accommodation to meet such acute needs. They will further free up under-occupied family homes. And the benefits of delivering 16 homes capable of meeting the acute need is a material consideration of significant weight. It's agreed that Latchingdon is an established village with a number of services and facilities. It's agreed these facilities are all accessible by foot, cycle and public transport. And further, the HELAR, the Housing and Economic Land Assessment, and the officer's report consider that the site is accessible and suitable for residential development, and the reason for refusal does not suggest the contrary. In terms of the sustainability of the settlement, in recognition of the failings of the previous assessment, the rural facility studies have been updated. It's an objective assessment that's intended to form a robust basis for decision-making. It concludes that Latchingdon is a larger village, and it's the fourth most sustainable larger village. In the light of this assessment, the authority has proposed to reclassify Latchingdon as a larger village in the emerging plan. It follows that the site lies in an accessible location, adjacent to a sustainable settlement. Indeed, such a conclusion is consistent with the grants of consent on 2 sites immediately adjacent to the site-specific HELAR, and the officer report. There are no unacceptable impacts to infrastructure and highways which cannot be addressed by Conditional 106, and it follows that very significant weight is derived from the social role of sustainable development. In terms of the economic role, the application has demonstrated the socio-economic benefits of the proposal, and they're not contested. I set those out briefly, sir. These economic benefits are an important material consideration in support of the proposal. Consistent with previous decisions in the NPPF paragraph 85, they should be afforded significant weight, and it follows that the proposal derives very significant support from the social and economic roles of sustainable development. In terms of the environmental role, it's agreed that there are no adverse impacts in respect of flooding, noise, air pollution or heritage. Turning to the community public open space, 4.25 hectares of the site would be multifunctional and publicly accessible public open space. That is 42% of the site. It will be managed and maintained in perpetuity. It will include informal open space, a kickabout area, youth provision, allotments and 2 children's play areas. It responds to deficiencies identified in the authority's green infrastructure strategy and is supported by the NPPF imperative to achieve healthy, inclusive and safe places which encourage healthy lifestyles. This is a very significant new area of open space which will be available to existing and proposed residents and is a benefit of significant weight. And such a large area will allow for an agreed significant net gain in biodiversity, with a biodiversity net gain of 30.41% in habitats and 40.51% in linear features. This is a benefit of moderate weight. And it follows that this proposal is that rare development which delivers benefits across all 3 roles of sustainable development. The only claimed environmental harm is to the identity of Latchingdon. On that point, the site is not internationally, nationally or locally designated. It's a non-designated site. It's not a valued landscape. It has no statutory status nor identified quality in the development plan. It's not therefore protected by NPPF 180A. Further, it's common ground that there's no objection on landscape grounds. It's also agreed that a high-quality development can be delivered at the reserved matters stage and that there is no impact to residential amenity. The sole issue is whether there is an unacceptable impact on the identity of Latchingdon within the terms of Policy S112. The appellant submits that the proposals would protect the settlement character and identity of Latchingdon, as its experience from the approaches to it. The broad linear character of the settlement will remain. The existence of the village as a settlement within a predominantly agricultural landscape will remain. Indeed, the new settlement edge will improve the interface between the raw settlement edge, comprising the rear of modern housing and the countryside to the east. The extensive areas of public open space and high-quality landscaping will provide an attractive and valuable feature for new and existing residents. In effect, the proposals would move the modern edge of the village eastwards into an area of unremarkable agricultural land, which is already heavily influenced by the existing modern settlement edge. The proposals would in fact soften the integration of the settlement into the landscape and provide a visual improvement to the way in which the proposals relate to the countryside. It follows that on balance, the proposal represents sustainable development and complies with the framework, which strongly supports it, and that is a further material consideration in support of the proposals. And it follows, sir, that material considerations outweigh the conflict with the development plan, and it's therefore the appellant's case that permission should be granted subject to the conditions in the 106.
Thank you, Mr. Cannock, for that. I'll ask now for Mr. Wilcox to deliver his opening statement on behalf of the local authority. Thank you very much. I'll number this for the purposes of the inquiry as ID 2. I'm wondering whether these documents can be uploaded to the council's website so that everyone who wants to see them can, given the limited number of copies, that would be appreciated if that could be
I'm
arranged.
sure that can be done, so yes.
Thank you.
It certainly won't be done by me, but I'm sure someone on my side is able to deal with that. Sir, thank you very much. I must begin by apologising for the state of my voice. I'm afraid I'm emerging from a horrible cough, so sorry for being hoarse and croaky, and if I collapse into a coughing fit, I'll apologise in advance for that as well. So the appellant seeks outline permission, as you know, for up to 160 dwellings with all matters reserved save for access on land to the north of the Groves, Burnham Road, Latchingdon. I'll call them the proposal and the site, respectively. So the site is an undeveloped greenfield location in the countryside adjacent to the eastern edge of Latchingdon village. On 14th of June 2023, the local planning authority refused permission for the proposal. The basis of that decision is reflected in the single reason for refusal, which I set out. So the essence of the council's case is this. The proposal is contrary to the development plan, will harm the character and identity of Latchingdon as a rural settlement, and there are no material considerations weighty enough to justify departure from the development plan conflict. Turning, sir, to the main issues and the nature of the dispute, as you identified in your opening, sir, your case management conference note identified 3 main issues for consideration. They're set out and I won't read them. So since the CMC, the dispute between the parties has narrowed somewhat. The following points of agreement are worth noting at this stage. 1, the parties are agreed that the district can demonstrate 5.97 years housing land supply, so that the development plan is not out of date in NPPF terms. 2, the planning witnesses appear to agree that the development plan is consistent with the latest iteration of the NPPF, subject to a minor point about policy S8, which I'll explore in evidence. 3, the council's confirmed it doesn't take a landscape or visual objection to the proposal. 4, the council no longer relies on development plan policies D1 or H4 as grounds for refusal, essentially because they're policies which will become relevant at the reserved matters stage. 5, the planning witnesses are agreed that the proposal is contrary to policies S1, S2 and S8 as cited in the reason for refusal. And 6, the planning witnesses appear to agree that the proposal is thereby contrary to the development plan as a whole. So given that extensive agreement, the dispute between the main parties is now really very narrow. It turns on 2 main questions. 1, does the proposal harm the character and identity of Latchingdon? And 2, are the planning benefits sufficient to overcome the presumption against development which conflicts with the development plan? Turning to the policy framework, the local and national policies relevant to the appeal are agreed and are set out in the Statement of Common Ground, as you'll have seen. It's worth emphasising at the outset of the inquiry, sir, the absolutely central role of the development plan as the driver of development decisions in the locality. In particular, it must be recalled, sir, the development plan has legal priority over the MPPF. I set out there, sir, a well-known quote from Lord Justice Lindblom in the Hopkins Holmes case, which confirms that point. The central purpose of the development plan, sir, is also stressed by the MPPF itself. Paragraph 12 of the MPPF notes that developments which conflict with an up-to-date development plan, as this one does, should, and I quote, not usually be granted. That important principle, sir, must be borne in mind throughout the next few days. Turning to the policies, sir, the parties agree the proposal conflicts with 3 development plan policies. Policy S1 is the district's sustainable development policy. It establishes a number of key principles to be applied in development control decisions. Those principles include delivering growth in the most sustainable locations and maintaining the rural character of the district without compromising the identity of its individual settlements. Policy S2 provides the spatial strategy to meet development needs and is the site allocations policy for the district. It's agreed that the appeal site is not allocated for housing or indeed for any other form of development, nor is the proposal windfall development or supported by a neighbourhood plan. Policy S8 establishes the settlement hierarchy and boundaries and sets a framework for the protection of the intrinsic character and beauty of the countryside. It does so by establishing a test for when development will be permitted beyond settlement boundaries. And that test is in 2 parts. 1, the development must not adversely impact on the character and beauty of the countryside. And 2, the development must be one of a wide range of types which are recognised by policy as supporting a sustainable rural economy. It's common ground, sir, that the proposal is not within any of that wide range of permissible development types. Turning to the main issues, sir, main issue 1, the suite of up-to-date development plan policies in this case, which I've just described, establish a clear framework for considering the suitability of developments in the countryside. The purpose of that framework is to protect the intrinsic value of the countryside and to restrict rural development to the kind that benefits and supports the rural economy. The most relevant policy for this purpose is S8, which sets out the comprehensive test I've described for addressing such proposals. As already explained, that test has 2 limbs. Policy compliance is dependent on both limbs being satisfied. It's common ground here that the second limb is not satisfied, so the policy test is failed. So that is not a technical breach, as the appellant suggests. The plan's framework is the result of the detailed, democratic process of local plan preparation and examination. That process resulted in a decision that proposals such as this one are unacceptable in locations such as this one. In a plan-led system, sir, that decision is not a technicality. It goes right to the heart of the acceptability of this proposal. Main issue 2 concerns the impact on the character of Latchingdon. Latchingdon, sir, under the plan is a small village of some 500 dwellings that retains the essential linear character which has defined agricultural villages of this size and in this location for centuries. The development would increase the number of homes in Latchingdon by around 33% and would increase the area of development in the settlement by about 53%. It would compromise the agricultural setting of the village as well as its historic linear form. Such a dramatic increase in the size and shape of the settlement will obviously have an impact on its character and identity. It's hard to see, sir, how it couldn't. That impact is exacerbated yet further when it's considered on a cumulative basis with the 162 dwellings which already have permission to be developed beyond the Latchingdon settlement boundaries since the start of the plan period in 2014. Those permissions, sir, were largely as a result of the former historic now application of the tilted balance in the Malden district. Furthermore, so the development would have an indisputable impact on the site itself, turning it from agricultural fields into a busy modern housing estate, with the associated light, noise and vehicular movements, as well as the introduction of a large amount of new built form. Again, sir, it's hard to see how that could not impact on the character of the settlement. It's worth noting, sir, that the council's concerns here, the concerns I've set out, are not landscape and visual ones. The L&V impact of a scheme is relevant to its impact on settlement character, but it's not decisive. In this case, the relevant harms arise irrespective of the landscape and visual position, which is why the council's not called a landscape and visual witness. Turning, sir, to the planning balance, perhaps the most important factor in the planning balance is the parties' agreement that the proposal is contrary to the adopted development plan, the key relevant policies of which are up to date. The starting point and legislative presumption, therefore, is that the appeal should be dismissed. Are there material considerations which outweigh that conflict? Or, to use the language of the NPPF, is the proposal unusual enough to be permitted despite the development plan conflict? The council, sir, will show through its evidence that the answer to those questions is no. The proposal undoubtedly delivers planning benefits, but these are nothing out of the ordinary for a modern housing scheme. In that regard, it's critical to recall that the council can demonstrate a healthy housing land supply of 5.97 years. Now, I accept that the housing land supply figure doesn't represent a cap on housing delivery in an area. Nevertheless, where an authority has a healthy supply, as this one does, then the presumption in favour of the development plan applies with greater force than where there is no 5-year supply. The NPPF itself proceeds on that basis, so as you'll be well aware, the tilted balance is not engaged in cases like this one. One area where the proposal's benefits go beyond that of a generic housing scheme, so is in respect of affordable housing. We recognise that in providing 50% affordable units, the proposal exceeds the 40% policy requirement. We also recognise the pressing need for more affordable homes in the Malden area. So that's why Mr. Coleman, as you'll have seen from his proof, has attached substantial weight to this factor in his planning balance, the same as Mr. Armstrong has for the appellant. The fact that an area needs affordable housing does not, however, justify delivering that housing in the wrong location. The council will show that the site is simply not the right place for these houses. The plan-led system will see the required homes delivered in the right locations without the need for proposals which are contrary to policy. And finally, within the planning balance, there are a number of smaller disputes around the weighting of various planning benefits. They'll be explored in evidence, but ultimately, sir, those are matters for your judgment. In the final analysis, sir, the appeal boils down to a simple issue. Is there sufficient justification for a fairly ordinary housing development to take place in a location which is not supported by the development plan? The council will show that there is no such justification, and on that basis will invite you, sir, to dismiss the appeal and refuse permission for the proposal. Thank you very much.
Thank you, Mr. Wilcox, for that. I think I'm going to take a short break shortly, but I just wanted to check before we hear from those who want to speak about the development, members of the public. Just wanted to check how many people actually do want to speak. On this list I have here, I just have 3 people, one of which is Anthony Fitzgerald, Peter Entwistle and Councillor Fissock. Are those people here? They're all here. Right. Are there any other people that want to speak? I'm not. The problem is that I'm aware that some people probably aren't actually in this room. Is that correct? They're in an overflow room, and therefore they're not going to be able to answer me. So what I think would be a good idea is to check during the break, if we can just check to make sure that there are no other speakers that want to address the inquiry. And if there are other people, of course, I'm more than happy to hear from them. So if we can do that during the break, that would be helpful. I'm not quite clear where the other people are. Are they fairly nearby, or they are? Right, good. Okay.
My understanding is people didn't want to sort of come and go and disturb.
I
You
see.
That's why they're in the other room.
Right.
That's at least my understanding.
Yes, because I mean there are a few spaces here if people did want to attend, but that's fine. If we can just check that there are no other speakers in the break, and then we'll hear from those speakers. So we'll have it's now 25 minutes past 11. We'll come back at 11:45. Okay, so the live streaming should hopefully terminate.
Yep.
Thank you.
Just transferring that over now, and you
So
You're live again.
thank you very much. As I said before the break, I'm proposing to hear from public speakers and any councillors as well that wish to address the inquiry. So far, I have the following: Anthony Fitzgerald, Peter Entwistle, Councillor Fittick and Councillor Stamp. Do we know whether there were any other people that wanted to speak? No? All right. Well, I mean, in no particular order, apart from those, the way they're listed on my list. I'm happy to hear from Mr. Fitzgerald first, if he wants. Is Mr. Fitzgerald here? If Mr. Fitzgerald, if you could come up to one of the chairs where there's a microphone, and address the inquiry. I should say that, strictly speaking, the opposing side, I assume you're speaking against the development. Yeah, strictly speaking, Mr. Cannock, one of these chairs should be fine. Mr. Cannock does have the option of asking questions of you. Mr. Cannock, I don't know whether you're proposing to exercise that option. In my experience, often barristers let members of the public speak, unless there's some very specific point that they want to ask.
Yes, I'll adopt that style of approach, sir.
Yeah, thank you, Mr. Cannock. That's helpful.
Subject to questions of clarification or,
indeed.
or egregious statements. Yes.
Indeed, quite. Okay, so Mr. Fitzgerald, if you'd like to just introduce yourself, and if you can say whether you're in favour or against. I assume you're against, and if you're a local resident, perhaps you could just give an indication as to where you live. That don't have to give the exact details, but just the general location would be helpful.
No problems. Okay. Good morning, everyone. It is still morning. My name's Anthony Fitzgerald. I'm a resident of Lawling Road in Latchingdon. I represent the residents of Latchingdon protest group. The NIMBYs, as we're earmarked in the media these days, ridiculed in the media in some circles. We're the people that actually live nearby, the people that actually work nearby. We're the people that it's going to directly affect where we live and how we live. You was pointing out earlier that just a point that was made about the visual impact on the village. When you do your site visit, sir, I would urge you to come down from Mayland and just look at the village. Coming down from Mayland, you see the church, the steeple, the big sky. That would have a visual impact by putting that development where you're proposing to put it. A massive impact. If you can imagine something of the ilk of Ely Cathedral, you can see it from everywhere. Latchingdon Church is a little bit like that as you approach it from the east. So it will definitely have a visual impact. Now you were stating about professional, what's the word I'm looking for? Do you know, I've never sat in a public inquiry before, so please excuse me. I'm quite good at speaking.
It's fine.
Professional opinion. The only professional opinion that I can offer you is that of a professional road user. I'm a transport manager. I've run road haulage vehicles for most of my career, so I'm pretty good with roads. And one of the things that I will tell you is that the road in and out of Latchingdon, where it converges, at the end there at the mini roundabout by the church, if you'd like to go and look at a website called Essex Air, it gives you the air quality right at that junction, right where them two roads converge, which is where there's a primary school, and the air quality is medium. That is comparable of underneath the Dartford Bridge. Medium air quality in a rural village right next to a primary school. I think that if you go ahead with this development, you're only going to add to that. More traffic equals more bad air quality. But if you look at the whole of the Dengie 100 on that map, that is the only place where there is medium air quality, where the traffic converges. And the reason the traffic converges there is because if somebody parks outside the shop in Latchingdon, the whole of the Dengie 100 pretty much comes to a standstill. And that's fact. So every morning there was a nice big queue through Latchingdon. Yeah, you know, and we're just going to add to that if we add more houses. Just going to add to it. Yeah, so all I can do is talk to you as a resident, you know. As I say, I've lived in Latchingdon 36 years in the same place in Lawling Road, and this proposed development is going to certainly impact my outlook. It will probably stop me from being able to use my property in the way that I've previously enjoyed using my property. So from a personal standpoint, and not just myself, I know that other residents of Latchingdon have also got the same problem, because we're totally unoverlooked at the moment. Yeah, so going forward, if that changes, and I can tell you now, I can report to this council now that one resident of Lawling Road has moved out of the house. The house is vacant in Lawling Road. It hasn't been sold yet as a direct result of this proposed development. So we're going to be moving people wholesale by the look of it, if it goes ahead. But there you go. Yeah, nothing else to add really. Anybody want to ask me any questions?
Thank you, Mr. Fitzgerald, for making your concerns heard. Just to reiterate what I said earlier, I am very aware of the concerns that local residents have about this proposal. I've heard, well, I've obviously heard what you've said this morning, but I've read a lot of letters of objection as well. So I, you know, be assured that I am aware of those concerns.
Yeah, wonderful.
So unless you have anything else to add, I've noted what you've said, and that so that's fine.
Yeah. So anything else you've got in writing anyway. So.
Yeah, indeed. Okay. Well, thank you, Mr. Entwistle, for your contribution.
Fitzgerald. Entwistle's over there.
Sorry, Mr. Fitzgerald. Mr. Fitzgerald, I apologise. Yes, Mr. Entwistle's next on my list. I do apologise for that.
Good morning, sir. Good morning, committee. And again, can I apologise? I'm not familiar with speaking in front of all, the committees of like this. And also, I actually thought it might only be allocated 2 minutes. So you'll be pleased to know that my comments are very, very brief.
There's no, given this is a public inquiry, unlike a council meeting, we don't usually impose such
I wasn't sure.
Stringent requirements, but brevity is always appreciated. So, yeah.
Well, as you said in your earlier comments, which were very much appreciated, we don't need to go over all the objections and complaints that you have received, because you obviously read them and they've been noted and taken into consideration. And also, we don't have the background for laws, rules, regulations, and technicalities that Catesby and these guys can. So that's not really our point to come across. I can only really speak as a resident of Latchingdon for 24 years. I live on the Burnham Road. So before when I moved in, we didn't have any of the 4 or 5 developments that have gone through in Latchingdon. So we've seen the visual impact of how the village has changed, and especially how the traffic has increased. My points, and those brought earlier in the other committee and those by the others, were 100% agreed by the 24 committee members, as we know, voted 24-0 last time. Those local committee members are people that live in the area. They understand the area. They know how the Dengie works and what's the implication of the roads, etc. are. What I say to Catesby's, I understand we need development. We need to grow. We all understand that. We understand this. But it needs to be done in the right place. Filling up villages and places that are poor road quality is not the answer to our problems. I live on the Dengie. Burnham, Southminster, and all the other villages to the east of us are building hundreds, if not thousands, of houses. And this is the one point that I really wanted to bring to you, sir, because I know you've got many comments. Of those areas in the Dengie, there are only 3 roads that come off. And as Tony pointed out, 2 of those roads meet at the very point that you are trying to build this development. Of those 2 roads, the residents already endure heavy traffic, congestion, long queues, and often long delays for 2 hours in the morning and in the evening. This is now happening in the day and at weekends. Are we really going to build a large development at that very spot? It's almost beyond belief. And I know I'm obviously quite passionate about it, but are we really going down that route? To add to this, as Tony said, there's a primary school that was built locally many years ago for the local residents. That primary school is on that very junction. The developers, as I say, they have to bring potential sites. We get that, but clearly they haven't looked into the homework and have shown their complete lack of knowledge in the area. And I say that, you know, in my personal opinion. If it wasn't for the farmer being dangled, you know, the pound signs in front of him, he would agree with the very comments that we are all making. It's just that obviously, you know, finance talks. As I said in the last meeting, I obviously don't agree. The 24 committee members didn't agree. And we can only talk as locals and residents in the area. Thanks for hearing me. And is there anything anyone would like to ask me? And apologise for my blundering ways.
No, Mr. Entwistle, thank you very much. I don't think, Mr. Cannock, you have any particular points, do you?
No, thank you, Mr.
Right,
Entwistle.
thank you very much.
Thank you, Mr. Entwistle.
6 out of 10, I'll go myself.
Right, okay. Then the next person on my list who wants to speak is Councillor Fittock. Is Councillor Fittock here?
Thank you, Chair. I'm Councillor Tony Fittock. I'm Chairman of Latchingdon Parish Council, Chairman of the Dengie 100 Group of Parishes and District Councillor for the Hawthorne Ward.
Sorry, can I just take a note? You say, so you're a district councillor and a local councillor, a parish councillor?
Chairman of the Latchingdon Parish Council, Chairman of the Dengie 100 Group of Parishes and District Councillor for the Hawthorne Ward.
Okay. So for the ward of Latchington?
Yes.
Yeah. Okay.
The Hawthorne Ward covers Latchingdon, Hawthorne, Mundon and Maylandsea.
Okay, thank you.
Thank you, sir. I've sort of had to change what I'm going to say, I guess, based upon some of the information that's been provided to you via the applicants for the development. It would seem that a great deal of store is being placed on the case for the need for affordable housing within the district. And the 2021 local housing need assessment that indicated that we'd need was 174 affordable rented or social houses per year and 35 intermediate rented. Now, at that point in time, it is true to say that the district had not really provided very many affordable houses. And given that position, the assessment concluded that in order to meet the local housing need, it concluded that it basically matched the planned target of 310. It came out at 308, which included a 49% uplift in affordability to help with affordable housing. The assessment also concluded that in order to meet a requirement of 522 houses per year to afford that 209 target would be inappropriate, and that the number of houses built should not be influenced by the market houses. It's just a false mechanical reference. If we were, however, to look at the situation now in 2023, when we did the 5-year housing land supply assessment, the affordability ratio had actually improved, and therefore we only need a 42% uplift. So on the one hand, in 2021, it was 11.71. I think this year it was 10.87. So are we really saying that over that period of time affordability has improved? Well, obviously it has. The assessment makes it very clear that it's an assessment over a point in time. You can't usually project forward or backwards. It's an assessment as it was then. And part of that assessment will be the inclusion of relets. And at that point in time, the relets were only 50. Well, given the fact that we hadn't built very much affordable housing up to that point in time, you could reasonably conclude that that number would be significantly different now, because in the last couple of years, or 3 years, we've built over 500 affordable houses. So I don't really think that looking back at data that has historically been provided is going to really give us very much of a forecast of what's required in the future. There's much reference in the report and the planning document to substantiate the departure from the local development plan based upon an officer's opinion on how the development plan is progressing. Well, again, you can look at these numbers in various different ways. Yes, it is true that we're not meeting the plan trajectory set out in the local development plan, but a plan trajectory was not anything other than the ability to try to predict the point in time that we'd need infrastructure. Now, originally, the primary infrastructure required was the expansion of Plume, which was expected to be in 2019, 2020. Well, it's fair to say that these strategic sites have developed slower than was originally forecast, but I think it's also fair to conclude that we did have a pandemic in the middle of it. Now, that undoubtedly had an effect on the delivery of the spatial plan, and it was reflected by the government in its reduction within the housing delivery target measurement of 3 months and 1 month to show that there was some impact on development. So again, I'd say that we can use numbers in whichever way we want to use, and I really think we should focus on what we need for the future rather than what has happened in the past. Moving forward, we have, according to the 2023 local AMS, we've got around about 5,900 consents when you include Burnham Walters Phase 3 in it. Against the planned target, we'd build around about 2,800. So we still have circa 3,000 houses that have been approved left to develop. We have about 7 years, say 5 years, 6 years of the plan. The standard method now indicates 279. So we have plenty of future supply over and above the plan requirement. I think it is fair to say that there has been greenbelt development approved throughout the plan process, but you could also argue that was done in a position of tilt and it was required to make sure that we've got sufficient future supply, which we do now have. The most significant development, yes, was a significant development that was greenfield, but that was for specialist housing for the elderly people in Burnham Walters, some 600 houses. So in terms of where we are as a development plan, arguably, we're pretty much on target now. At the last assessment, using the prior plan target, we would be 109 houses behind the required amount over the plan period. If you look at the projection for this year, we're going to actually exceed that position, and it looks like we're going to do so moving forward. So personally, I feel that we're in a very strong position as a local authority in terms of our delivery of our local development plan and the future moving forward. So where does that leave us? When I joined the council, one of the first things that I attended was a planning session. And within that planning session, there was a slide. And on that slide, it basically said this: why do we have a local development plan? And members were asked to think about the matter. And the answer to that from the person that was presenting it was that, and it was a man looking over a field at his fence, open field. To provide certainty to residents was the answer that the consultant gave us on that matter. So why do we have a local development plan? We have a local development plan because it's an agreement, as I see it, a contract between ourselves, the government and the residents with respect to how many houses we'll build over a period of time and where they will get built. And by doing so, there is some certainty to residents that if they buy our property in a certain location, and for businesses if they wish to develop their business, that there will be some certainty of what will happen next. We're left in a position whereby, because of situations that have arisen, a development has come forward that sits outside of the local development plan, and therefore it clearly does not accord to the spatial shape that the members set out, in agreement with the government, in agreement with the residents. And we're asked to depart away from that. Well, it's interesting to note that in the recent review of the NPPF, the government has made great efforts to try to ensure that local development plans are better protected moving forward. I'm sure, sir, you are aware that in many appeals, significant challenges will be undertaken by applicants challenging the 5-year housing land supply position, especially when it gets towards the end of a plan and in formation of a new plan, because it'll always revolve around the interpretation of some modelling judgment, I would say, how long will things take to build, and at what speed will they build out at? Well, nobody really knows the answer to these questions, but we seek to answer that question by putting all of this data onto a spreadsheet that then informs us as to whether or not our plan is sound. Well, our plan is sound. We have 5.97 years. When we look at the changes to the MPPF, it's very clear that we'll be moving soon towards the spatial shape that would require us to only demonstrate a 4-year housing land supply when we reach the regulation 18 stage. And on adoption of a local development plan, there'll be protection for the district against falling below the 5-year housing land supply for a period of 5 years after adoption. So given the fact that we've got 3,100 consents already sitting out there, and that the government are looking to allow the councils to include oversupply in future 5-year housing land supply petitions, unless something significant happens, the council really is in an extremely strong position. So why did the government make the changes to the MPPF? Despite great opposition from developers, because it sees the value of protecting the interest of residents and ensuring that residents are actively involved in any consultation process. Well, it might well be in the fullness of time that as we move forward as a district council and we determine what our spatial approach should be, and whether Latchingdon remains a large village, becomes a medium village, or becomes a small village, are matters to be debated by members at the appropriate point in time and decide based upon an evidence-based approach accordingly. We may or may not decide that the location that this applicant is proposing is the most suitable to meet that growth requirement that we determine for the future. And that will be determined by what the responses we get from the residents and the members accordingly, not by developers and not necessarily only by officers. So I really do feel that if we do allow departure from the plan for really technical reasons, such as affordable housing or social economic benefit, then what's the point of having a local development plan in the first place? Because every single development that comes forward will offer exactly the same benefits. So what's the difference between this one and the other one? There'll be no point having plans. So I really would urge you, sir, to dismiss the appeal, because I really don't see that the benefits of departure outweigh the significant departure from the local development plan. Thank you.
Right, thank you. Thank you, Councillor Fittick. You did raise quite a lot of detailed information in that your submission there. I was wondering whether it would be helpful, certainly for me, if you could do a sort of summary of what you've said in writing and put it into the inquiry, because you did make a number of quite detailed points, and I think it would be helpful to have those in writing, rather than, to make sure that I captured, that I've got everything before me that you said, because you did, as I say, there was a lot there. Is that possible? You could do that?
Indeed, it's probably already done actually, so I'll just get it across to you.
That would be helpful, and we'll put that in as an inquiry document so that it's before the inquiry. I'll just check to see whether Mr. Cannock wants to ask you any questions, Mr. Cannock.
I don't, sir. No, thank you. There are a number of points and what I might call technical points about numbers and things, but I'm going to pick those up with Mr. Coleman in due course. So whilst obviously I don't accept what was said, I don't want to duplicate matters, and I don't think you'll thank me for putting the same matters twice. So with that sort of caveat, sir, now I've got no questions.
Thank you, Mr. Cannock. That's helpful. As I say, it would be helpful, Councillor, if you could just put it doesn't need to be a lengthy note, but just essentially summarising what you've just said. That would be really helpful from my perspective.
Certainly.
Thank you. Okay, Councillor Fittick, thank you very much. And then Councillor Stamp, thank you. Thank you, Councillor Stamp. If you just introduce yourself, and I'll let you.
Thank you, sir. Thank you, everybody. My name's Councillor Wendy Stamp. I'm dual-hatted at the moment. I'm a county councillor and I'm also a Malden district councillor. So I wasn't going to speak, but and hopefully you will indulge me, because what I want to say, Mr. Coleman won't be surprised at what I'm going to say, because at the EIP appeal hearings, when our original LDP was heard, I spoke a great deal on education. Well, I know it is not the statutory consultee is Essex County Council. I'm not speaking on their behalf. I'm speaking on my behalf as the local representative who has to deal with many, many issues when we get overdevelopment and infrastructure that isn't actually keeping pace with the number of houses that seems to be developed and built out. So what I'd like to say, sir, is that we know Essex County Council is has a statutory duty to provide places in mainstream and outside mainstream education, which is for children who go to the local primary schools, secondary schools, and also I'm a massive advocate for SEND provision. You may not be interested to know, but I marched in Downing Street to try and raise awareness for the lack of provision in this area. We don't have any special schools out here. In the Malden district, and more appropriately in the Dengie, where this development would go. Looking at the number of houses that is looking to be approved and 50% affordable, that inevitably will include houses and families with houses including large families, which will put a weight and a pressure on the school places. As I said, Mr. Coleman heard me speaking at the original inquiry where Mr. Keylock was the education person for Essex County Council, and I wasn't actually a member of the public who's referred to as Mrs. Stamp, and I wasn't a councillor, but it inspired me to actually stand and become a councillor, because my forecasts, even though the inspector acknowledged they most probably were accurate, but because do I call him Mr. Nunn? Sir. Inspector, it has sadly come to fruition. In front of me have the up-to-date school figures and shortages of school placements around our area. Now, some of you won't know, but this development where it's going to be, yes, there is a primary school, and yes, there is some places left. But if you come to the other side, where parents still have a choice sometimes of people going into school places, we don't have such a vast choice for our senior school, our secondary schools. And through hard work, we've managed to get a couple of form entries at Ormiston. Plume is bursting at the seams. I can't remember who actually mentioned about the expansion of it, but it isn't coming in time with all these development. Councillor Fittock actually spoke the best that you'll ever hear about figures. He's an absolute godsend to understand data and be able to explain it fully and openly to everybody so they can all understand it. My main concern is that if you do allow this development where it is, the school places won't keep up, whether or not Essex County Council, they can't, you know for a fact, Inspector, they can't refuse it. They can only take financial contributions because that's how the law works. Correct me if I'm wrong, I'm sure the barristers will if I'm incorrect there, and I apologise if I've misled the inquiry. So you're always going to have a contribution. Now we know there is a huge lag of those contributions being delivered in this district. So if yet again we have this you see fit to approve this appeal, we're just going to be back to square one. We don't have enough school places out here, and we know that the County Council has said that there has to be a minimum of 4,500 in the next plan to be able to get a primary school in the area. Now that actually won't equate and won't keep up with the other infrastructure deficiencies we actually have. So whilst I know it's not a reason that you're considering, I would actually ask you to think about it, about the impact of where this development's going to be, the impact on the schools around it, because the children will not be able to walk to school. Yes, they might be able to walk to the primary school. They can't walk to a secondary school. They will be bused. Essex County Council is looking at resources, so we all know that they're not be providing the transport that most probably is necessary, which then will result in the number of cars going on the road, which actually, was it Mr. Fitzgerald who said about the cars, or whoever said about that junction on Latchingdon? My biggest postbag, Inspector, is about that Latchingdon High Street. We've got a road closure coming up which everybody's absolutely dreading because it absolutely brings the Dengie, Burnham and the other roads to a standstill once you've got a road closure for roadworks. Now, they have to be done, but what you've got to understand, and you will understand it when you get there, when you go out to the site, is we usually have a one road in, one way road out. If this development, Mr. Inspector, was at the other end of the village, I don't think there'd be so many people who was against it. All the development that's taken place so far is the wrong end of the village. It should be where the other main roads are, and you've got other roads coming in and out of the district and the Dengie. So I haven't got anything else to say, but thank you for allowing me to speak, and I'd like to thank the residents for actually being brave enough. It's not easy to sit and speak at one of these inquiries, but hopefully you've listened and read all the things as what you've said. So thank you very much.
Thank you, Councillor Stamp, for that. As I say, I'm very aware of the concerns of local residents, and I've heard what people have said this morning, and I appreciate it is a rather formal business public inquiry, and sometimes people find it difficult to make the points, but I think everyone's made their points very well this morning, so that's fine. And of course, I've got the large number of letters that people have written as well, so that's fine. I've got no further. Mr. Cannock, I should ask you, of course, whether you had any questions of Mrs. Stamp, Councillor Stamp.
No, I didn't. So can I though just to assist you in considering some of those points, give you a reference. I'm not quite sure where you are with the core documents, but it's CD, so core document 2.1. It's the officer's report. It's section 4.4.3, and this is where it deals with education, primary education, secondary education, in particular school transport contributions. But this is a matter that we'll be looking at through the SIL compliance statement and the section 106 in due course. So perhaps I can just give you that note and leave it there.
Thank you, Mr. Cannock. I appreciate that the official position of the council is that they haven't raised objections in respect of what we might broadly term infrastructure, education, and so on. That's my understanding of the situation. I appreciate that councillors and local residents may not, their views may not align with that position, but that the council's official position is that they haven't raised these concerns as such.
Yes, so being slightly pedantic about it, neither the council as local planning authority nor Essex as the local education authority. So there's a consensus between the two.
Yeah. Understand that, Mr. Cannock. Thank you. Okay, fine. Right, just before we finish this part of the inquiry, just to make sure, these are the only people on my list that I've had requests to speak. Are there any other people that want to speak? No? All right, well, thank you all very much for your contributions, and we'll move on to the next stage of the inquiry, which in fact is the formal evidence stage. As I said earlier, we'll hear the council first on that. Now, it's 12:20. I don't know, Mr. Wilcox, how long you might be in chief with your witness.
Well, sir, I'm not planning to have Mr. Coleman read out anything because you've read the proof, and I'm not sure it will assist you. So I've got a few pages of questions just to expand on some of the key points and to draw out the main threads of evidence. I'd thought I'll be in the region of 45 minutes. So.
Right. Well, we have two options. We can either break for lunch now, have an early lunch, and hear the chief after lunch, or we can start chief now.
Well, sir, I think my slight preference would be to have an early lunch, if that's right. Of course, under the new professional guidance.
Yes, I'm aware of. Indeed, I'm aware of this new professional guidance, which essentially says that whereas previously people weren't restricted, as it were, after chief. They are now, as I understand it, under these new professional guidelines.
Right. I think, strictly speaking, they always should have been, but the practice slipped. But yes, I don't want to condemn Mr. Coleman to a lonely sandwich. So no, perhaps this is the solution.
No, Mr. Cannock, do you have any observations on that?
Yes, sir. My preference would be we've got 45 minutes now before 1 o'clock to hear the examination in chief, and then from 2 till 5 we've got 3 hours of cross-examination. My concern is that otherwise we're going to have 4 hours of evidence, sort of, with maybe potentially a sort of 10-minute break in between, and that's quite a heavy afternoon, which I will do, but I think that's less preferable to starting now. So that's what I would encourage you to do, but I'll abide by whatever you tell me to do.
The problem is, Mr. Canuck, with these new rules that we've got, in some respects, my view is that if people are in chief, then I can't really see what the problem is of them not, being in what we used to call PERDA, but those are the rules are the rules, or guidance as it is.
Perhaps, sir, a helpful solution would be to take a slightly shorter lunch and a slightly longer afternoon break.
Yeah.
So as to perhaps if we take 40 minutes for lunch and a half an hour break at an appropriate point in Mr. Canuck's cross-examination.
Okay.
That might be the.
All right.
That might be the way to.
So we take a break now then.
Take a break now.
Yeah.
Come back at 1 o'clock. I'll get going. We'll get straight into cross and.
Okay. All right. Well, we'll do it that way then. We'll do it that way. We'll break until 1 o'clock, and then we'll hear chief, and then we'll have a short break after that. So if we resume, then we'll adjourn now, and we'll resume at 1 o'clock.
So might I be